We all know corporate directors and officers shouldn't lie and shouldn't steal. But what if they learn that someone else might be lying or stealing? Do they have a duty to investigate? The United States Supreme Court considered these questions in Bates versus Dresser. Edwin Dresser was the president of a small bank in Cambridge, Massachusetts. During Dresser's tenure, the bank employed George Coleman as a bookkeeper. Between 1904 and 1910, Coleman stole several $100s from the bank. Coleman concealed his theft by manipulating the bank's ledger and deceiving the bank's cashier. Neither the cashier nor any bank examiner ever detected any wrongdoing, and the bank's directors accordingly relied on the cashier's and examiner's reports that all deposits and assets were properly accounted for. Dresser, however, was personally involved in the bank's daily operations. Dresser was at the bank every day and had constant access to the bank's ledger. In addition, Dresser was informed of suspicious activity by bank employees on 2 occasions. In 1905, a teller informed Dresser that he believed somebody was stealing money. And in 1908, another employee told Dresser about the suspicious disappearance of a package containing $150. The employee told Dresser that he was wary of Coleman because it seemed that Coleman's lifestyle exceeded what he could afford on his salary. In both instances, Dresser declined to investigate. The bank eventually went into receivership, and the receiver, John Bates, sued Dresser and the bank's directors to recover the amount stolen by Coleman. Bates argued that the losses were attributable to Dresser and the directors' violation of their duty to monitor the bank's affairs. The district court agreed and held both Dresser and the directors liable. The First Circuit reversed, ruling that only Dresser was personally liable. Dresser and Bates appealed to the United States Supreme Court.